All right, welcome back. Freedom of expression. All right, so we're talking about free speech, freedom of expression. From this point forward, we can use those two terms interchangeably. So we have something known as the preferred position doctrine, which this is something that the Supreme Court uses when they are deciding free speech cases. Free speech is fundamental to liberty. Therefore, any limit must address severe, imminent threats. In other words, free speech is our most important liberty. If we don't have free speech, we do not have liberty. We are not free. It is fundamental to liberty. So, if free speech is allowed to be limited in any way, those limits have to be constrained to just things that address severe, imminent threats. So some types of speech now. We're going to deal with speech that is constitutionally protected. Symbolic speech is constitutionally protected. It's defined as actions that purposefully convey a particular message or statement. In other words, it doesn't have to be only the words that are spoken and come out of your mouth. Signs, symbols, as you see to the right there, flag burning, those are all forms of symbolic speech, and they all are constitutionally protected. Hate speech is also constitutionally protected, as long as it doesn't call for imminent lawless action. So there we go again with that word imminent. Imminent means that something is about to happen soon, in a timely manner. So as long as hate speech doesn't call for illegal action to take place very, very soon, it's protected. So you do have a right to be racist and say racist things. Speech can be limited. So we have four types here: libel, slander, obscenity, and imminent lawless action. So we'll look at each of those four. Libel is a written lie, and libel is allowed to be prevented. So you can sue somebody for committing libel if they have written about you in a lying manner. Now, libel is very difficult to prove because, again, the preferred position is to allow speech as much as possible, but you are allowed to sue for libel. But in the United States, the standard of convicting somebody of libel is very, very tough. You have to show that it's incorrect and untrue, which is easy enough, but you also have to show that it was malicious, that there is a malicious intent, that they intentionally lied about you in order to harm you. Very tough to do. Slander is a spoken lie, so just like a written lie can be limited, so can slander. Slander is a spoken lie. Otherwise, those two are the same. Obscenity. So this is a very tough term to define. And so the Supreme Court has said that obscenity is allowed to be limited, but you notice here the first four words, it's going to be based on community standards. So that means that this obscenity is relative, depending on where you are and when you are. Something that can be obscene in one place may not be viewed as obscene in another. So this is going to be a very subjective one. This is going to be very tough for the court to determine. So based on community standards, something that is offensive and lacking value. So for example, something like some kind of nudity could be, you could argue that has artistic value perhaps. Maybe it has some kind of scientific value. So those things wouldn't be obscene, but if they lack some sort of artistic or scientific or political value and are offensive based on the community standards, it could potentially be restricted. All right, so we have a Supreme Court case here, Brandenburg versus Ohio, 1969. To be completely honest with you, I feel like this should be the case that the AP test requires instead of Schenck versus the US, but they ain't asked me, so here it is. And this is the most current, up-to-date interpretation of free speech. All right, so this is the current interpretation, which is that speech can be limited if it is inciting imminent illegal action or is likely to produce such action. So in this case, this was a hate speech case, like that cartoon is showing with the KKK. They had held a rally in which they had said all these awful things and had said essentially that that their members and white people should take back power from minorities and from Jewish people, and that they should do all these bad things to them. But the Supreme Court allowed that speech, saying that it did not actually incite imminent illegal action, and it was not likely to produce such an action. All right, so subscribe if you haven't already. Hit that like button. This has been a La Money production.
to